In this lesson, we're revising judicial precedent, and that's, of course, just a fancy way of saying how judges follow past decisions. We can think of it a bit like a rule book that grows every time a case is decided. So in this lesson, we're going to go over what it is, how it works, and why it's so important for keeping the law consistent. Plus, we'll also look at how judges sometimes need to tweak it. And this is key for your exams, so it's really worth paying attention, maybe going over the lesson a couple of times to help you revise. Now, these are the lesson objectives, and by the end of this session, you should have covered all of this. And also, it provides you with a pretty good tick list, so you can go back to these original objectives at the end or at the end of your revision and just double check, can I do all of those things? Can I explain what judicial precedent is? For example, can I describe the court hierarchy? Because you can pretty much be asked about any of those issues within those 10 markers, or of course, even at the 28 markers or evaluation questions too. So it's really important that you're able to put a tick next to each of those after you've done your revision. Now we're going to go back to basics here. So let's start with what judges actually do. So a judge is responsible for running a court, of course, and to do so fairly and making sure that the law is correctly applied. Now, in all cases, judges interpret and apply legal rules to the facts in front of them. Now, in jury trials, of course, the judge isn't there to decide the guilt. They guide the jury on the law and they make sure that the trial is fair. We also have judge-only trials, and here the judge both decides the law and the facts. So they assess the evidence, they ensure proper courtroom procedures followed, they maintain order, they've got a lot to do, haven't they? And finally, they pass sentences in criminal cases. If it's a civil case, they make awards as well, perhaps in disputes. So essentially, the judge is the referee of the courtroom and makes sure everyone plays by the rules. And also they apply the law correctly. So judges set judicial precedent, but what is that? And that's what we're going to be looking at, of course. So it's also called case law, and you can see it called judge-made law as well. All means the same thing. At its core, judicial precedent is basically the principle that courts follow the decisions made in these earlier cases when the facts are similar. Now, this ensures fairness and consistency, because similar cases, therefore, are all treated alike. And it allows people, lawyers and judges, to anticipate likely outcomes in legal disputes as well. So before we go any further, we'll take a quick step back in history here and the history of precedent. So judicial precedent in England really started to develop after the Norman Conquest way back in 1066. So back then, courts didn't rely much on written laws like we do today. Instead, judges made decisions based on customs and what other judges had decided before them. You can see where we're going with this. So over time, these decisions were then written down and they started to become an official source of law. And by the 19th century, following past decisions, which is what we now call judicial precedent, well, this was a key part of the legal system. Now, this is how common law developed. It's basically just law that grows case by case, rather than coming only from Parliament. So now judicial law is when courts look at earlier cases with similar facts and follow the same reasoning. And we do this because we want the law to be fair, we want the law to be predictable. I mean, if you imagine every case was decided differently depending on the judge's mood, that would be total chaos, wouldn't it? Precedent really makes the law more like a game where everyone has to know the rules and follow them. And it leads to everybody knowing what to expect. We're going to look at the hierarchy of courts now. And the reason we're going to do this is because the hierarchy of the courts is really the backbone of judicial precedent. You can think of the hierarchy as a bit like a pyramid. So, the narrower up to the top it is, the higher up. The more powerful it is, the more influence its decisions have on all the courts below it. Now, at the very top, we have the Supreme Court, and its decisions are binding on every other court in England and Wales. Now, what does that mean? Well, it means that if the Supreme Court makes a ruling on a legal issue, Well, that's it. All lower courts have to follow that decision, no matter what. The Supreme Court also follows its own past decisions usually. Although there is a bit of wiggle room, the practice statement of 1966 means that it can depart from past decisions, its own past decisions, when justice or society's needs require that change, but we will look at that in a bit more detail later. Now, next we have the Court of Appeal, and its decisions bind all lower courts like the High Court and the Crown Court. Usually the Court of Appeal follows its own previous decisions, but there are important exceptions, known bizarrely as the Young versus Bristol aeroplane rules. And these are very, very important exceptions, and we will again have a little bit of a closer look at these in some later slides. Next down we have the High Court. Its decisions bind lower courts, such as the Crown Court, county courts and magistrates' courts. And the High Court usually follows its own past decisions too, but it has more flexibility than the Court of Appeal. And finally, we have the Crown Court, county courts and magistrate courts. And these courts are bound by all the decisions of those higher courts you see there above them, but their own decisions don't create binding precedents for other courts at the same level. Moving on then to law reporting and why it's so important. Well, precedent's only going to work if judges and lawyers can actually find those previous cases that we've been talking about. And that's why accurate law reporting is so important, because historically judges and lawyers, well, they relied on printed law reports, books that recorded the decisions of past cases. You can see all those books there behind Judge Rinder. Now, these reports could take ages to find and they weren't always complete. So that made the job of precedent a little trickier. But, advancements in technology, we're much luckier nowadays because we've got electronic databases like Lexis and Westlaw. And this makes it much quicker and far easier to access up-to-date case law. So judges can see exactly what was decided, what reasoning was used in the case, and how it might apply to the case in front of them. And there's a big chess piece there because you can think of it like playing chess. If you've never seen any past games, you wouldn't know the strategies, you wouldn't know the traps, your moves would be guesswork. So accurate law reports are like those past games. They guide judges' decisions today. They help them follow established rules. They help them avoid mistakes as well, and also maintain consistency in the law. So without them, well, the whole system of precedent would fall apart. So accurate law reporting is incredibly important when it comes to judicial precedent. Now, binding and persuasive elements. So every case has two main parts that we need to understand. Now, the first is what we call the ratio decidendi. And this literally translates to the reason for deciding. This is the legal principle or rule that is binding on future courts. So this is the bit that we really need to pay attention to. And as I said, it's the legal principle or rule that's binding on future courts when they deal with similar cases. In other words, it's the bit of the case that sets the precedent. Now, the second part is the obiter dicta, and this means things said by the way. So these are like those extra comments, maybe observations made by the judge, maybe some side notes that the judge has made, a little bit like little notes in the margin, if you like. They weren't binding, or they aren't binding, so other courts don't have to follow them. But they are useful because they can be quite persuasive. So, for example, a judge might mention a hypothetical situation or maybe suggest how the law could apply in a slightly different case. And then later judges can look at the obiter dicta, those comments if they want to, but they aren't forced to. So for your exams, it's really important that you can identify the ratio decidendi because that's what counts for precedent, of course. The obiter dicta is useful too, especially if you want to show a deeper understanding or discuss how the law might develop. But remember, it's the ratio, that's the core legal rule that binds future cases. So have a quick practice of this. We've got a fictional case here, Brown versus White. Mr. Brown left a trampoline in his garden without a safety net. A neighbour's child climbed over the fence and got injured. The court ruled that homeowners must take reasonable precautions to prevent foreseeable injuries to visitors. The judgment also discussed whether children climbing over fences was common in similar neighbourhoods. And you can see here quite clearly, there's the ratio decidendi. That's the binding part of the case. Homeowners must take reasonable precautions to prevent foreseeable injuries to visitors. That's kind of what they have to do. That's the binding part. And then we've got some additional comments, the obiter dicta, which is useful but not binding. So, the court discussed whether children climbing over fences was common. Here's another one. Green versus City Council. Ms. Green slipped on a wet floor in a public library. The court held that public authorities owe a duty of care to ensure premises are reasonably safe for visitors. And the judge added libraries should also consider putting up temporary warning signs during cleaning. So have a look at that one. And we'll reveal the answer now. It's pretty clear, isn't it? The part there in yellow, public authorities owe a duty of care to ensure premises are reasonably safe. That's the binding part. So that's the ratio decidendi. That's the part that sets the precedent. And then we have the libraries should also consider putting up temporary. That's a bit of advice, isn't it? A bit extra that the judge is given. So that would be our obiter dicta. It's interesting. It might be useful, might be persuasive, but it isn't binding. So let's move on to flexibility. We've been talking a lot about how judges need to follow precedent because it makes sure it's consistent and fair and predictable. But of course, what about if that precedent seems to be an older case maybe, and if we followed that older case, it might lead to like an unfair or maybe even outdated outcome. And that would be what we would call an awkward precedent. So what we need to do is make sure that judges have some wiggle room, if you like, to avoid these awkward precedents. So let's consider what judges can do if the previous case, if one of these older cases would not lead to a satisfactory outcome. They've got a couple of tools here to manage this situation. The first is called distinguishing. So a judge may decide that the current case is different enough or sufficiently different from a previous case so that the old rule just, doesn't apply. This case is too different. We don't need to apply that old rule. For example, a case about trespassing might not apply if the person in the current case was lawfully on the property. It's different enough. We can distinguish between the two. So basically what's happening with distinguishing is that the judge is recognising that the facts matter and different facts may require a different legal outcome. We've also got overruling. That's another thing judges can use to avoid these awkward precedents. So a higher court can overrule an earlier decision if it believes that that decision was basically wrong. Now this establishes a new rule that binds future cases. So the new case basically establishes the new rule. We see this a lot. We'll take a look at a case where this happened, which is the R versus Jogi case. So this is where the Supreme Court's ruling on joint enterprise corrected previous misunderstandings and basically reset, if you like, it set the new precedent for future cases. Now, the last tool that the judge has at their disposal is reversing. So when a case is appealed, basically the higher court reverses the decision of the lower court, and that just changes the outcome, doesn't it, for that specific case, but it doesn't create a general rule for other cases. It's just specific to that case. So you can think of it a bit like following a recipe. Usually you follow it carefully, but sometimes the ingredients or maybe the conditions are a bit different, so you adapt. Or you might realise the old recipe was flawed, so you adjust it for future attempts. And judges do the same with precedent. They follow past decisions, but they have ways to adapt and correct mistakes to ensure that justice is achieved. I mentioned this earlier. This is the practice statement, and this applies to the Supreme Court. Let's have a little bit of a closer look at what it even means. So the practice statement from 1966. Now this was introduced because the House of Lords, that we now call the Supreme Court, recognised that strictly following precedent could sometimes lead to unfair or outdated decisions. Now, before 1966, the House of Lords treated its previous decisions as absolutely binding. That is it. And this meant that even if a past ruling was clearly wrong and no longer reflected modern law, the Lords had to follow it. And this could create injustice and even confusion in the law. So the practice statement was brought in, and it gave the House of Lords a bit of flexibility, meaning that they could depart from their own past decisions when it appears right to do so. In other words, they can overrule previous decisions if, and only if, sticking to them would produce an unfair result or hinder the development of the law. We are going to have a little look at the practice statement in action now with these key cases. So I'll have a look at them one at a time. So let's start with this real classic example of the practice statement in action. So we start off with Addy versus Dumbreck from 1929. Now this shows why the practice statement was really needed, how important it was that it came in. So back in 1929, there was a case called Addy versus Dumbreck. And it involved a little boy, a little child, trespassing on a colliery owned by Dumbreck. That's where the name comes from. And this child tragically died as a result. And at the time, the law, as interpreted by the House of Lords, well, really, it gave very little protection to trespassers. It's a bit like, if you trespass, you take your chances. And that basically meant that the owner of the colliery owed almost no duty of care, no need to put up signs and fences and all the rest of it. Now, this decision caused, as you can imagine, a lot of criticism because it seemed unfair to the child and their family. But the House of Lords had to follow previous decisions. What could they do? They couldn't change the law, even if it didn't make sense anymore. Now, this changed in 1972. Remember, the practice statement had come in 1966. So another case came called the Harrington versus British Railway Board in 1972. It's a not dissimilar case really, because in this case, a child trespassed on an electrified railway and was seriously injured. And the House of Lords, who now of course had the practice statement, because that being brought out in 1966, and they used the practice statement to depart from that old Addy and Dumbreck rule way back from the 20s. And they held that railway companies and occupiers more generally owed a duty of care to trespassers, at least to take reasonable steps to prevent injury in dangerous situations. So, maybe putting up fences and signs and so on. So Addy versus Dumbreck shows how strict precedent can produce really unjust outcomes prior to the practice statement. And then Harrington shows how the practice statement that came out in 1966, well, that allows the law to adapt, which makes it, of course, much fairer and much more in line with modern society. We can't just keep following old rules blindly. Another couple of cases here for you. So another good example of the practice statement in action is R versus Shivpuri from 1986. Now, this was a case where Shivpuri was caught trying to deal with what he believed were illegal drugs. However, it later turned out the substances weren't actually drugs. He thought they were, but they were actually harmless. So under the old law, the courts had previously ruled you basically can't be guilty of attempting an impossible crime. He could never have sold drugs because, unbeknown to him, he didn't have drugs. So technically, he couldn't be guilty of that crime because it was impossible to complete. Seems a bit ridiculous, doesn't it? I mean, the intention was the same after all. So the House of Lords used the practice statement from 1966 to overrule that previous decision, and they held that a person can be guilty of attempting a crime even if it's impossible to complete, as his crime was, of course, as long as they intended to commit the crime and took steps towards it. So that case shows how the practice statement allows the law to correct past mistakes and adapt to ensure that justice is done. Let's look at the next case. So this is R versus Jogi in 2016. Now, this was a really interesting case and very recent too. So it completely changed the law on joint enterprise in murder cases. So Jogi, that's him there on the left, he and an accomplice went to confront a man, and during this confrontation, Jogi's accomplice stabbed the victim, who later died. So under the old law of joint enterprise, Jogi was convicted of murder as well, because the court said that if he foresaw the possibility that his accomplice might commit murder, he could be guilty, even if he didn't intend the killing. Now, when it went to appeal, the Supreme Court used the practice statement to overrule these earlier decisions, saying this interpretation of the joint enterprise rule was wrong. So they clarified that foresight is not the same as intent. So to be guilty under joint enterprise now, a person must really intentionally assist or encourage a crime, not merely be aware it might happen. And it was a very important case because it corrected decades of law, because they'd been following the old joint enterprise rule precedent for years. So it corrected decades of law that could unfairly convict people who were involved in a crime but didn't, actually actively intend murder. And it's a very clear example of how the practice statement allows the law to adapt and make sure that justice is done. I mentioned this earlier, Young versus Bristol Aeroplane. So let's move away from the Supreme Court now, and we'll take a look at the Court of Appeal. Okay. Now, the Young versus Bristol Aeroplane, and we're going to explain when the Court of Appeal can ignore its own past decisions. If you remember at the beginning, I said they usually have to follow their own past decisions, but this provides a little bit of flexibility. Now, the case started with Mr. Young. As you can imagine now, he worked for the Bristol Aeroplane Company and he was overpaid by mistake. And the company later deducted money from his wages to cover it. And Young argued these deductions were unlawful. So when the case reached the Court of Appeal, the judges realised that actually there were some conflicting past Court of Appeal decisions on this or on similar issues to this. So, oh dear, what do we do? And so it raised a very important legal question. Does the Court of Appeal always have to follow its own past decisions, even if they contradict each other? And to answer this, the court then clarified 3 exceptions. And now these are now known as the Young exceptions, and they're really useful when talking about courts avoiding awkward precedents. For example, so the first of these is conflicting previous decisions. So what does this mean? It basically means if the Court of Appeal has made 2 past rulings that contradict each other, well, you can't follow both, can you? You don't have to follow both. You have to just choose one. You choose the one to adopt. So it's a bit like, if you had 2 textbooks that gave you different answers to a problem, you just pick the one that makes the most sense. A bit like that. And it's one way that the court can avoid these kind of awkward precedents without causing chaos. The next rule or exception, that it brought about was what they call overruled by a higher court. Now, if the Supreme Court or House of Lords has overruled an earlier court, remember those 2 things are the same, of course. It used to be called the House of Lords, we now call it the Supreme Court. So if the Supreme Court has overruled an earlier Court of Appeal decision, well, the Court of Appeal must now follow that higher court. So that's all it means. Basically, they have to follow what the Supreme Court have said. So if the Supreme Court have overruled something, well, then the Court of Appeal have to follow that precedent. There's an example here in Miliangos versus George Frank, where the House of Lords, as they were, overruled earlier decisions about awarding damages only in sterling. The case itself isn't too important, but what it shows is the court avoiding an outdated precedent because a higher court has already corrected it. So they basically look to the higher court for guidance. And then finally, we have an earlier decision was made in error, or the Latin for that is made per incurium. So here, the Court of Appeal can ignore a past decision if it was clearly made in error. For example, if the earlier court basically made a mistake, maybe they overlooked a relevant statute, maybe they overlooked a binding authority of some kind. I've got a couple of cases there that you could look up in your own time, and this is where earlier rulings basically had serious legal mistakes. So it allows the court to get around unsatisfactory precedents. So in short, the Court of Appeal is usually bound by its own decisions, but if there's going to be a bit of a unsatisfactory outcome, well then these three exceptions, the young exceptions, give it a bit of flexibility while still keeping the law consistent and predictable. So let's take a look at the Privy Council. So this is the part the part of the Privy Council that we're most interested in is called the Judicial Committee. And it's basically a really, really senior court. It's made up of all the top judges, including some from our own Supreme Court as well. And these days it mostly hears appeals from Commonwealth countries and UK overseas territories. Now this is the key point really for your exam, and it's really important to know this actually. The Privy Council decisions, well, they're not binding. Okay, they're not binding. They don't form part of that pyramid, part of that hierarchy. The Privy Council's decisions are not binding on courts in England and Wales. However, they can be persuasive. So judges don't have to follow them, but when they're interpreting the law, they often look at them for guidance, especially if there isn't much English case law on a particular issue. So it's a bit like, getting advice from a really knowledgeable neighbour. You're not required to do what they say, but you'd be silly to ignore them completely. So a bit of easy history to help it stick. The Privy Council is actually one of the oldest parts of the government. And hundreds of years ago, it was the monarch's, the king or queen's main advisory group. So dealing with politics, law, pretty much everything else. And over time, most of those jobs shifted to Parliament and the Cabinet. But one part survived, and that's what we call the Judicial Committee part of the Privy Council. So that's the bit that still acts as a final court of appeal for countries that share our common law roots. But remember, those decisions are not binding on courts in England and Wales. So the key takeaway really is it's not binding, but it's often very helpful. So should judges make law? Well, officially judges are meant to interpret the law, aren't they? They're not meant to make it. But in reality, sometimes they do end up creating new law, especially because society has changed and Parliament maybe hasn't updated those rules yet. So here's a few famous examples that we may already have covered. First of all, you've got the Donahue versus Stevenson, and this is the famous snail in the ginger beer case. So before this, the law on who owed a duty of care was a bit all over the place. So judges created the modern idea that you must take reasonable care to avoid harming your neighbour, basically people who could be affected by your actions. And that principle didn't come from a statute. So the principle of duty of care, interestingly, came from case law. Judges developed it. Next, we've got Gillick from 1985, and this is where we get the phrase Gillick competence from. Now, this was a case where the court had to decide whether a child under 16 could consent to medical treatment without their parents' consent. So Parliament hadn't really set clear rules on that. And so judges created the idea of what we call Gillick competence, which basically means that a child can make decisions if they fully understand what's involved. And then finally, we've got R versus R, one we've looked at before. So historically, of course, the law assumed a husband could not rape his wife, which I think we're very much in agreement that this is an incredibly outdated idea. By 1991, society had really changed and moved on. But Parliament basically hadn't changed that old rule. It still stood. So basically, judges abolished the marital rape exemption and confirmed that rape within marriage is a crime. And this was a major development, actually, in criminal law. So even though the official line is that judges don't make the law, in practice, they sometimes have to. So when Parliament hasn't kept up with modern life, it's up to judges, isn't it, to step in and fill in those gaps, if you like. So to finish off, we'll take a look at some advantages and disadvantages. So why do we even bother with precedent? Why not just let every judge decide on each case's merits? Let the judges decide however they like. Why do they have to refer to previous laws, the precedents? Well, precedent gives the legal system some really important benefits. First of all, it makes the law certain and predictable, which is really important. People can work out what the likely outcome will be. Lawyers can advise clients properly. You don't want the law to change like a weather vane, depending on which way the judge you get on the day goes. We want to have some idea, don't we, when we go into court, of what to expect. Next, we have fairness and consistency. So if two cases have similar facts, well, they should have similar outcomes, shouldn't they? That's basic fairness. Precedent helps keep decisions aligned. Also, we've got efficiency. So judges don't need to reinvent the wheel every time. They can look back at previous precedent. So if a principle's already been decided, well, great, they can use it instead of starting from zero every time. So it speeds things up. And then gradual development. The law basically evolves. It's always changing. It's not one thing. It's always evolving bit by bit. It doesn't jump around suddenly. It adapts actually quite slowly and gradually as society changes. And that's much safer than great big dramatic changes all the time. You can think of it a bit like a Lego tower. Each case basically adds a new brick, and over time you get a strong, stable structure. So without those bricks stacking on top of each other, the whole system would be quite wobbly. Of course, precedent isn't perfect. It has some real downsides as well that you need to know for your exam too. So it's slow and it's rigid. So because it's slow to change basically, isn't it? Because courts usually have to follow past cases. So the law can get stuck with old rules that don't match modern life. And sometimes judges want to update the law, but unless a higher court steps in, they can't. Could be complex as well. There are thousands of cases, and working out which one applies can feel like trying to find the right page in a great big textbook that never ends. Another disadvantage is that it can lead to unfair outcomes. So sometimes an old case just doesn't fit the situation in front of the judge, but they still have to follow it. So the right legal rule might produce a result that feels morally wrong today, for example. And finally, it depends on good reporting. If a previous case was badly written up or reported incorrectly, or the key ratio is hard to find, then a judge might end up relying on the wrong principle. So really, there's this constant tension between certainty, which we know is very important in law, where everyone knows the rules, versus flexibility, which is also important in law, and means being able to change the rules when we need to. And it's a bit of a balancing act, and the legal system is always trying to get that balance right. So we'll just talk very quickly about the top of the court hierarchy, the Supreme Court. Now this, as we've said, this is the highest court in the UK, and its decisions bind every other court below it, no exceptions. And that's why its rulings are so influential. This is the top dog. Once the Supreme Court sets a legal precedent, well, the rest of the system has to follow it. A bit of history: before 2009, the highest court wasn't the Supreme Court at all. It was the Appellate Committee of the House of Lords. And the judges who sat there were known as the Law Lords. And when the Supreme Court was created, those judges and their powers were transferred over to a new, separate and more independent court. And it was designed to create a clearer separation between the judiciary and Parliament. Now, one of the key powers the Supreme Court inherited was the ability to depart from its own past decisions when justice requires it, as we've already talked about. We've already seen how this works with cases like Jogi. So the key point is this: the Supreme Court is the only court with this level of flexibility. All other courts must stay within the boundaries of precedent unless a higher court gives them a new direction. So the Supreme Court, it's a bit like the rule keeper of the legal system. Most of the time it reinforces consistency by sticking to its previous decisions. But when the law becomes outdated or confusing or unfair, it does have the authority to step in and adjust the rules to keep the system working properly.